All right, Sierra Leone decides 2023. Sierra Leone Supreme Court has made a landmark ruling in favor of President Julius Maada Bio's decision to change the country's electoral system to proportional representation electoral system ahead of the June 24th multi-tier elections. Sierra Leone's Chief Justice Desmond Babatunde Edwards, in agreement with 4 other justices, said the directive of President Bio told the Electoral Commission of Sierra Leone to hold the June 24th elections for ordinary members of parliament by the proportional representation electoral system is constitutional. The case was brought by lawyers representing the opposition APC party, JFK, Joseph Fitzgerald Camara and partners, on behalf of the first plaintiff, Abdul Kabo, a member of parliament, and the second plaintiff, Councillor Hakiratu Maxwell Kolka, against the Attorney General and Minister of Justice as first defendant, and the Electoral Commission of Sierra Leone as the second defendant, respectively. In their ruling, the Supreme Court Justices Desmond Babatunde Edwards, who was the presiding judge, Nicholas Brown-Mark, M. Dean Tarawali, Alusain Sisi, and AICC, dismissed all claims made by the plaintiff's lawyers. An order restraining the second defendant, Electoral Commission, its agents, servants, previsor, however, called from taking steps aimed at conducting the June 24th multi-tier elections on the district proportional representation electoral system is refused. Chief Justice Edwards said in agreement with his colleague justices, "Tonight, we are looking at the outcome of the judgment and where that puts the country for the June 24th elections." My name is Samuel Wise Bangura, and this is AYV on Sunday. All right, good evening and a very warm welcome to AYV on Sunday. Today we are looking at the judgment on the PR system and where that puts the country for the June 24th multi-tier elections this year. Yeah, with me, as always, I invite people who are in touch with the issues. But presently in the studio, I have lawyer Lansana Dumbuya, who is aspiring for the Secretary General post of the opposition All People's Congress Party. Good evening and welcome to the show, Lawyer Dumbuya.
Yeah, good evening, Samuel Wise, and good evening to viewers. All
right, we are with the Solicitor General, Lawyer Robert Kowa, to be part of the conversation, Lawyer Francis Gabidon, and Lawyer Rashid Dumbuya to be part of the panel tonight. But just before we get into the conversation here in the studio, you can always be part of our conversation, share your thoughts, ask your questions, just drop them on the AYV News Facebook page. We would go through some of them, but please, we always admonish that you tailor your comments or messages to the issues being discussed here on this program. In case you are listening to us on FM 101.7, good evening and welcome. Watching us on Channel 43 on AYV TV and on DSTV Channel 399, good evening to all of you from across Sierra Leone, the continent, and the rest of the world. This is AYV on Sunday. But just before we get into the issue itself, the court matter, our State House correspondent was with the presidential team as the president embarked on a nationwide tour. And a statement by the chairman of the Sierra Leone People's Party got him curious to put together this short clip. Let's take a look.
I want to address Una. This, Una listen keenly. I don't believe Una style where that MPB they talk. Give respect where respect is due. We don't encourage that in the SLPP. If you are SLPP, you behave maturely and responsibly. It was a very bad reaction. If you want to support anybody, it is full Una. That noise not going to make Ugan symbol. Make you learn. Say, Doctor, I did not talk. Go Una behave maturely, not to APC Kanaya. Let me am glad that woman don't left APC because the sound of woman. So do ya where would they talk? Say tell you gonna na Bambatu. Many message go na Bambatu. Do ya not want this? We don't pass all over this country. One for a year, we did the president they talk. I don't want to talk today, but for that now una message so. Now the bullet don't give una. I'd advise una the young man they would I don't smell na today. Do ya all the commander? Will they come back? If we get anything, the party hierarchy, they will not complain. And we not support the one who get forget symbol. We don't give symbol because we give symbol because you're Sierra Leonean. This is not PR system. Make we know that. So now we remain banner. We not going to banner no more. We not sabi. Now PR system we they give to a Sierra Leonean way worthy for be able to represent this country internally and externally.
That was Dr. Prince Alex Arden, chairman of the ruling Sierra Leone People's Party, making a comment there about the use of the proportional representation electoral system during the nationwide tour embarked on by the party's leader, who doubles as president of the Republic of Sierra Leone, Dr. Julius Maada Bio. Well, like I introduced earlier, the only guest present at the moment is lawyer Lansana Doumbouya, who is vying for the Secretary General position of the opposition All People's Congress Party. Once again, lawyer Doumbouya, good evening and welcome to AYV on Sunday. But let me also make it that whilst the conversation goes on, would welcome the country's Solicitor General, lawyer Robert Kowa, private legal practitioner Francis Gabidon, and the executive director for Legal Link, Rashid Doumbouya. Lawyer Doumbouya, first off, let me hear your take. What do you make of the judgment on Friday by the Supreme Court?
Well, for me, I've always argued the issue of the PR system vis-a-vis the Constitution, constitutional provision, Section 38 and 38A. And I disagree with the judgment of the Supreme Court, and I think it is within my right to do so. I believe that Sierra Leone should be a country where we should have a peer review, system on some of these judgments that are being issued out by whether it's the Magistrate Court, the High Court, or the Court of Appeal or Supreme Court. In other countries, you have legal arguments from legal academics. They will look at the judgments, they will criticize it, they will argue it, and after some time, the judges will look at those arguments as a peer review in good faith, and they will accept, some of the arguments that have been made. But in Sierra Leone, once you criticize a judgment, the magistrate frowns at you and he thinks that he's your enemy. The judge likewise, sometimes he does, but not all of them. But I can say, for me, I disagree with the judgment. I think it's outrightly wrong and it is unconstitutional that the PR system should be held at this point in time for these coming elections.
Just before I run through the declarations there. You mentioned the magistrates' courts, the high courts. These lower courts, for example, can have the appeals court overturn their judgment.
Yeah.
But the Supreme Court is the only, court that can, go back on its own judgment. Yeah. Have we gotten a precedent of such a situation in Sierra Leone, and whether or not there is the proclivity for this one in years to come?
There has been a few cases that's far back in some judgments, way back, But nowadays, the Supreme Court, well, generally they frown on turning back on their judgments. But I think any bench that is, properly constituted and a reasoned bench that would want the jurisprudence of this country to grow should be able to look at the decision. They should go back and look at it and read. Not that they will come outrightly immediately and say, this is wrong, but they should be able to discuss amongst themselves and say, no, I think we went, we were on the wrong path with regards to this particular argument. But it has not been the case in Sierra Leone, and it is sad that people do not want to look at their rulings and judgments and say to themselves, I have gone wrong in this area, and decide in the future to change and to go to a path where the jurisprudence of the country can be improved. I think we should begin to have some lawyers who are academics, or even if they are not academics, who are ready to criticize some of these judgments. But you see, again, the fact that you criticize a judgment does not mean you just criticize it. You have to give reasons why you're criticizing the judgment. And for me, with regards to what came out from the Supreme Court, I have argued here, even before the Supreme Court judgment, even before the argument was made by the plaintiff, that is the APC representative and the lawyers. I have argued here and in many other forums that there's no basis for the PR system. There's really no basis. I am looking at the judgment. It's strange to me that the Supreme Court should come out with that kind of decision. But for now, I have started looking at the judgment, and I really want to look at it properly and see. But from a cursory glance at it, I still disagree with it, vehemently.
Let's look at the judgment. So here is what the plaintiff's argument was. That, for example, in page 16, it says in his argument before this court, Learned Counsel for the plaintiffs, Dr. Abdullahi Usman Conte, submitted that the case was not about the merit or demerit of a proportional representation. At the heart of this case, he argued, was the crucial issue of whether the 2023 multi-tier elections involving parliamentary and local council election should be held through a proportional representation system, which he concluded strikes at the heart of the rule of law, in that whether, we can truly say as a country, we are governed by the rule of law and the Constitution of Sierra Leone. So he further submitted that the proportional representation was not an alternative system of election in a democratic country governed by the rule of law. Is that something to go with?
I still do not appreciate that argument, because the basis of the case before the court was that the PR system at this point in time was unconstitutional, and various sections of the Constitution were cited. And for me, I believe that, of course, any lawyer who has a case, whether he's opposing or for the argument, will want to put up a kind of argument, whether it's robust or not. But I believe that, for me, Mr. Conte is my friend, but I think that argument is neither here nor there. I disagree with that argument and believe that what is before the court is really the PR system, whether it's unconstitutional at this point in time. And I believe that Section 38 is the basis of all the arguments. Yes, 38A is the amendment, which is really the crux of the matter. But you begin from 38, because we are saying 38 is still in existence. That is the basis. I've argued it here, Mr. Wise. 38 is still in existence. There is nothing wrong with 38. It is when you have problems with 38 that you go to 38A. So what is the argument really? Whether it's from the state, whether it's the judges, what really is the argument is there? Can one proffer? Because Section 38 is saying that the country should goes into election to a constituency system. And the life of the constituency is within 5 and 7 years. 7 years ends next year, December. So what are you really talking about a PR system? Whichever argument you put, whether it's the Supreme Court, whether it's I disagree with their reasoning.
We will come to the declarations of the court. Yeah. Interestingly, we've been able to summarize them so that our viewers and our listeners will be able to understand them better. We've broken them down. We'll come to them shortly. But let's go back to Friday when the proceedings was on at the Supreme Court. Let's join Bakari Matia, who was part of the team that witnessed the judgment there at the Supreme Court.
This court hereby makes the following declaration. 1. That on the proper construction of Section 38A, 1 of Constitutional Amendment of Act Number 15, all conditions precedent for the holding of or conducting of general elections of ordinary members of parliament through a district block representative were met and or fulfilled. 2. That the directive given by His Excellency the President to the Electoral Commission of Sierra Leone to hold the 2023 elections, public elections for ordinary members of Parliament by the district block representation system instead of constituencies was in tandem with the provisions of Section 38.1 of the 1991 Constitution as amended and therefore not ultra-vires. 3. That the current Parliament will soon be dissolved and thereafter all constituencies currently existing will be extinguished for purposes of representation in Parliament in favor of representatives representing each of the 16 districts of Sierra Leone, inclusive of independent candidates who secure the minimum threshold for the attainment to securing of seats in Parliament. 4. That the division of constituencies as provided in Section 38.4 does lead to a restriction of the number and establishment of the subject to parliamentary approval. 5. That independent candidates can and are part of the electoral system and can stand and be voted for to be included in any of the seats represented in existing 16 districts in the country. 6. That statutory instruments number 13 and 14 of 16th November are part of the laws of Sierra Leone and are not altered by Section 33 and 38 of the Constitution Act No. 6 of 1991, Section 38A of the Constitution as amended in 2001, and Section 171 of the Public Elections Act No. 17 of 2001. 7. That pursuant to and subject to the current law in the country, inclusive of the Constitution and statutory instruments number 13 and 14 of 16 November 2002, local council election will be expected to be by district block representations approved as the vote for the 2020 elections. 8. An order restraining the second defendant, the Electoral Commission, its agents, servants, privets, or howsoever called, from taking steps aimed at conducting the 2023 multi-tier public elections on the district block representation system is refused. I say that again. An order restraining the second defendant, Electoral Commission, its agents, servants, privets, or howsoever called, from taking steps aimed at conducting the 2023 multi-tier public elections on the district block proportional representation system is refused. Emphasis mark. 9. An order directed the second defendant to hold the June 2023 elections for ordinary members of Parliament and Council on a constituency or ward basis is refused. Emphasis mark. Cost. On the issue of cost, this court notes that this is a public interest-based litigation and hence is not inclined to award the usual cost. A minimal cost is therefore awarded in the sum of 3,000 euros to be borne by both plaintiffs jointly and severally payable to the first and the second.
The ruling was in favor of the first and second defendant, the Attorney General and Minister of Justice and the Electoral Commission, respectively. Speaking to AYV, counsels representing them spoke on what the ruling meant for jurisprudence in general and how this ruling has cemented the once shaken trust people had on the Electoral Commission, Sierra Leone.
What does this mean for the profession? Of course, it's improving on the jurisprudence of Sierra Leone. And a lot of young colleagues will learn from that, and I believe these are things that will be discussed even on the street, the marketplace, and whatever. And I'm of the view that people appreciate the way it's being dealt with, because election touches and concerns every individual in this country.
Over the last 2 years or more, a lot of questions have been raised on the neutrality and impartiality of the Electoral Commission, our client, particularly so questioning the ability to conduct a credible elections. What the Supreme Court has said today is that they acted lawfully, legally, they followed the procedure, they consulted on it, which means this Electoral Commission, which a lot of people have been bashing, remains to be doing the right thing. So we're glad, firstly, to stamp that authority of neutrality and independence as a claim, but also to get a free hand to now continue with the electoral process.
Speaking on the way forward, Deputy Chairman of the Human Rights Commission, Sierra Leone, called on election management bodies to now ensure that the sensitization on the proportional representation system be intensified for electorates to understand, especially first-time voters.
It's only now left with ECSL and other institutions to ensure that those first-time voters are educated in how to go about the entire process itself, and those who are intending to contest as independent candidates are also given the opportunity to understand how this whole thing works out, and also in a matter of ensuring that they know the proportional representation is, to actually improve governance system, as the court has actually now put it. So we want to see that the ECSL and all other agencies that are responsible for elections, they take this particular moment down to the farthest areas to ensure that they educate people, so that people will come to understand how this whole thing works out, and then how Sierra Leoneans actually benefit from it all.
Councils representing the plaintiffs, politicians of the All People's Congress alike, promised to appropriately comment on the ruling another time. Bokari Matia, AYV News, Freetown.
All right, many thanks to Bokari Matia for putting that story together. And the story speaks to the judgment at the Supreme Court, the proceedings, and after judgment was handed down, he spoke to counsel representing the two defendants, the Attorney General and Minister of Justice, and the Electoral Commission, Sierra Leone. Of course, those who represented the plaintiffs did not comment at the time, and we're trying to also establish contact with them to tell us what do they make of the judgment handed out by the Supreme Court of Sierra Leone. But I still have lawyer Lansana Dumbuya here with me in the studio whilst we await the arrival of the country's Solicitor General, lawyer Robert Kowa, and legal private practitioner Francis Gabidon, lawyer, to join the conversation. Lawyer Dumbuya, you've just listened to the judgments and the lawyers who represented the two defendants, the Attorney General, Minister of Justice, and the Electoral Commissioner, the Solicitor General for the Attorney General, and lawyer Emmanuel Safa Abdullahi for the Electoral Commission, Sierra Leone. And you were referencing Section 38. And the first declaration, if I should just quote the Chief Justice directly, he says, all things considered, this court hereby makes the following declarations. One, that on a proper construction of Section 38A of the Constitution Amendment Act number 15 of 2001, all conditions precedent for the holding of or conducting of general elections of ordinary members of parliament through district block representation system were met and or fulfilled. And this has been your argument that, the conditions have not been there, but here's what the highest court of the land has decided, has interpreted.
No. You see, there is a snag there. Now, when you say all conditions precedent to the holding of a professional representation according to Section 38A have been met, if you look at the way and manner in which you go about promulgating, going about issuing out the order and also getting the necessary paperwork to be issued to the public, maybe you've met that, but that is not the point.
What's the point for you?
The point is, are we supposed to go to proportional representation? That is the point. That is the basis. Because, you see, I have noticed that they deliberately, there are places in the judgment where they've talked about Section 38, but Section 38 is the basis. You do not go into 38A until you have a problem with Section 38. And I sometimes it is difficult when you have a clear provision and you have people going around those clear provision, trying to portray it as something that is complicated when it is very plain and simple. It bothers me. And for the posterity of this country, we should not be toying with the very existence of the democracy of this country. And as I have said, I disagree with the judgment, and seriously.
On what basis? On what basis are you disagreeing?
On the basis that the holding of a proportional representation election by district level is unconstitutional at this point in time.
Even when the Supreme Court has said it is constitutional?
Well, that is why I said I disagree with their judgment. I mean, if the Supreme Court has said it, so that is what the country should accept for now.
The authority mandated.
Because except we appeal to God Almighty, there is nowhere else for us to appeal. But I think it is not a good decision for this country. And even before the judgment, you see the chairman of the SLPP before the judgment telling people that the proportional representation is going to hold, as if he knew what was in the judgment.
Like even members of the opposition would say, for example, no, we are not going by PR system before the judgment. Yes, but
no, that is because we believe that we should go by the Constitution. And the Constitution is clear, and it bothers me that at this point in time, we're trying to inject cloudiness into a clear provision of the Constitution. And that is what the Supreme Court, for me, has done. And I believe I would look at the judgment and I will write a piece out for them to see that I am not only criticizing the judgment because I hate members of the bench. On the contrary, all of them are my friends, I mean, a good number of them, all of them are my friends. But the fact that they issued out a judgment that I disagree with does not mean I should be smiling and say it's all well and fine. I disagree with their judgment. I think they are wrong, according to my own assessment. That does not mean I am a genius in the law and I am the most clever person in the law. I cannot claim that. But I believe that the provision relating to proportional representation, all the provisions are clear. And for me, cloudiness has been injected into it.
When you say cloudiness, looking at the second declaration, it says that the directive given by His Excellency the President to the Electoral Commission of Sierra Leone to all the 2023 public elections for ordinary members of parliament by the district block representation system instead of constituencies was in tandem with the provisions of Section 38A.
Yes,
Section
you see,
1
again.
Of the 1991 Constitution.
Again. Is it in tandem with Section 38?
A, subsection 1.
That is what I'm saying. Before you go to A, you must fulfill, or there must be a problem with Section 38. You don't just jump to 38A and say, we have fulfilled all the conditions in 38A. No, you don't do that. 38A is more or less like a proviso. If this system if this system cannot hold because of XYZ, you understand, then you go to Section 38A. And even for Section 38A, there are certain provisions in that particular section that have not been met.
Which
so, let me see. Don't know if you have the provision of the Section 38A there.
So for the purposes of those of you watching and listening to us, we still await the arrival of the country's Solicitor General, Lawyer Robert Kowa, the private legal practitioner of lawyer Francis Gabidon, and Rashid Dumbuya, lawyer, the executive director for Legal Link, to be part of the conversation tonight. But you continue to share with us your thoughts. We'll find time to go through some of them. Let me run through this, Lawyer Dumbuya. Now, you talk about the provisions that should be met 38 before going to 38A.
Yes.
Correct.
Yes.
Now, what the third and the fourth declarations are saying, that the current parliament will soon be dissolved, and thereafter all constituencies currently existing will be extinguished for the purposes of representation in parliament in favor of representatives representing each of the 16 districts of Sierra Leone, inclusive of independent candidates who secure the minimum threshold for the attainment or securing of seats in Parliament. And listen what the fourth declaration is saying. That the revision of constituencies as provided in section 38, subsection 4, does not lead to alteration of the number and or the establishment of constituencies subject to parliamentary approval.
I disagree. I disagree with those reasoning. You know, firstly, you know, as I say, a lot of things have been made cloudy, and that is a big problem for this country. The fact that Parliament will be dissolved, you know, in March or so, does not mean the life of the constituencies ends. You know, I mean, the provisions are there that the life of constituencies ends within 5 to 7 years. 5 to 7 years. So in March, the constituencies will be still existing until next year, December. So what I don't really see the argument there. To say, I mean, parliaments in many countries have been dissolved, but that does not extinguish the constituencies, you know, existing. Constituencies are always there. They are there. They've already been delimited and demarcated. They are there. The fact that the parliament is dissolved does not mean that the life of the constituencies ends. No, it doesn't. And I can say that clearly, and I will hold on to that, because the Constitution provides for the lifespan of constituencies. It says between 5 years is the minimum, 7 years is the maximum. And 7 years, the maximum, ends next year, December. So why should why should you say that because Parliament is going to be dissolved in March, therefore the life of the constituencies ends? I mean, that's unconstitutional to me.
What are your pointers, especially at this point when the highest court of the land has interpreted the very provision for which members of your party, took the Minister of Justice and Attorney General and the Electoral Commission too, and they relied on the judgment, on the wisdom of that very court. And that court has interpreted the very provision of the Constitution. And what's there to challenge?
Of course. No. We can't. There's nothing you're going to challenge anymore. But that does not mean one cannot criticize the judgment. Even the House of Lords, you know, there are many articles criticizing some aspect of the judgment or the whole reasoning of the judgment. That does not mean you're making enemies with the judges or no. This is peer review. When somebody, it's like you've written a book or an article. You do a peer review system where other people who are versed in the subject look at it and say, no, this argument, it does not hold water. You know, you should have taken this other limb of it. I disagree with this. And you see the argument goes back and forth from the author to the critics. They will go back and forth in good faith. It's not like they're going to fight in good faith. Say, okay, if you say this, what about this? This is where I was going. And similarly so with judgments. In many countries, you have people criticizing judgments of the court. It does not mean that you are belittling the court or whatnot. No, you are not. You know, but you have the right to criticize the judgment because you believe that you disagree with all the reasoning that they've proffered. And I believe that I disagree with the judgment so far.
Members of the APC, some are on record for saying that the PR electoral system does not make way or create room for independent candidates to contest. But in the interpretation of the Supreme Court, it's saying, in the sixth declaration, that the statutory instrument, the fifth declaration is saying that independent candidates can and are part of the electoral system and can stand and be voted for to be included in any of the seats representing the existing 16 districts in the country. How can they do it? Regulations have been developed by the Electoral Commission that has the mandate to do so.
No, you don't develop a regulation. You see, we are bastardizing the Constitution and we feel good with the way we do it. The Electoral Commissioner cannot go and create a system. The Constitution, Section 38A, you know, the very Constitution, the basis upon which the Supreme Court has now ruled, did not say anything about independent candidates. It talks about political parties. So political parties draw up a list and profile a list and put, a list on the district block system. Go back to the section 38A. It does not say anything. It makes no provision for independent candidates. And that is the truth. But again, let us assume for once. I mean, for me, I like to play the devil's advocate. Let us assume for once that the judge was right in his argument. Let us say he was right. For you to see how fair, I can be in my argument. Let us say he's right that independent candidates can come forward and vie and be elected to parliament. I want to ask you, Mr. Wise, how?
The last time I asked, well, the good thing I do the questioning, but I asked the representative from the Electoral Commission, and they were devising a model. They were putting together.
They cannot devise a model. This
because
is the thing.
They are saying that part of the statutory instruments taken to Parliament, they have the power to develop regulations and how the conduct of the elections would be, because they are mandated by law to do so. And they have come out saying, well, yes, and now the Supreme Court of the land is saying, of course, independent people can contest for parliamentary seats.
If the which I think is wrong, outrightly it's wrong for them to go develop a system that is not constitutional. But let us say for one.
But the court is saying it's constitutional. They have the mandate to do so. So when you say it's not constitutional.
Again, Mr. Wise, you go back to the Supreme Court. Yeah, yes. I am not talking. I have said I disagree with the Supreme Court, and I still hold on to my argument.
Right.
And I will try to do a paper on that, and I will try to do a paper on that and see how. And I will find a quiet time and do it properly and send it to them. Even the Chief Justice, I'll send a copy to him for him to know that this is how I believe I disagree with the judgment of the Supreme Court. But the point is this: how can you go and develop a system when you have not been given the mandate to do so?
What does that mean?
Because the parent legislation itself, 38A, talks about political parties. It did not say independent candidate. For example, in the Constitution, 1991 Constitution, for parliamentary seats, yes, it is true that the provision of the 1991 Constitution makes provision for independent candidates. That is for constituency. When you go on a constituency basis, it makes provision for independent candidates. But when you go to the PR system, 38A, there is nothing there. It is completely silent, and it did not say anything about independent candidate. It keeps on stressing on the issue of political parties, profiling a list on the district block system, political parties, which means if you want to go on the district block system or list system, you have to organize a political party.
And that opinion of yours, the Supreme Court is saying, no, it's wrong. We have a different view.
I agree with you. That is what they are saying. But as I say, I disagree with their judgment completely,
Listen to the 6th declaration. It says that statutory instrument number 13 and 14 of 16 November 2022 are part of the laws of Sierra Leone and are not ultra-various sections 33 and 38 of the Constitution, Act number 6 of 1991. Section 38A of the Constitution as amended in 2001 and Section 171 of the Public Elections Act number 17 of 2001. And the 7th is saying that pursuant to and subject to the current law in the country, inclusive of the Constitution and statutory instrument number 13 and 14 of 16 November 2022, local council elections will be expected by the district block representation system approved as the mode for the 2023 elections.
No. I don't think, you see, again, I don't know why the Supreme Court ventured into local council. The Supreme Court, they had no business going into that, because that's not the basis of the argument. For me, the local council, they don't have to even touch that, because it's going to bring a problem. There's a special provision dealing with local council election. You know that. There's a special provision dealing with that. And that provision came round about between 2002 to 2000 and, let me say 2000 to 2004. You know, the first local council elections were held in 2004. You know that? 2004. So the legislation must have, preceded that one, must have come, before the elections were held. So there is a prevailing legislation which was, promulgated by Parliament for local council elections. And the 2001 amendment only talks about parliamentary. It does not talk about local council. So if they want to lump it all, let them lump it all. It's the Supreme Court.
When you say this, it takes me to the argument presented by councils representing the plaintiffs. So they submitted lawyer Dr. Abdullahi Usman Conte, saying that the proportional representation was not an alternative system of election in a democratic country governed by the rule of law. He argued that it was Section 38A, subsection 1 of the Constitutional Amendment Act number 15 of 2001 that introduced such system, but that it must be read in conjunction with Section 38, subsection 1 of the Constitution of Sierra Leone,
I agree, absolutely.
Act number 6, which had imposed a constituency-based election, in which case it must be concluded that Section 38A is not or ultra-med. Of course, it's freestanding. So with these arguments submitted, and just listen to what he further said. Thus, he argued, the powers vested in Section 38A of the Constitutional Amendment must be exercised within the parameters of the Constitution Act number 6 of 1991, which provided that elections be constituencies based as in Section 38(1) thereof.
Yeah.
So, but then how the Supreme Court?
I agree with him, and
thinks otherwise.
I have made that same argument here way before even the matter came up, and I agree absolutely with him. As I say. That was a brilliant argument made, which I have already made in this forum and in other forum in the country. For now, the Supreme Court has made its decision, and there's not much one can do. But I believe that if the Electoral Commissioner is a man of substance, he ought not to go by the proportional representation system.
Even after the Supreme Court has...
Even after the Supreme Court issued out its judgment. It does not mean because the Supreme Court issued out its judgment, it is hook, line, and sinker for the country to jump on the bandwagon with proportional representation. The electoral commissioner should look at whether the country is really ready for such a system. I have argued it here many times.
So listen to this.
How can you change? Let me say this, Mr.
Yes.
Sorry about that.
Go ahead.
You cannot change the goalpost from the two ends of the field to put the goalpost at the side of the field at the 11th hour, when the match should be 90 minutes, when it is almost 85 minutes, 5 minutes, you say you are changing the goalpost. The goalpost should not ever be at the end, it should be at the side. That is what the Electoral Commissioner wants to do.
Listen to this declaration when you mentioned that the Chief Electoral Commissioner can just, veer away from the judgment of the Supreme Court. And it says, an order restraining the second defendant, of course, the Electoral Commission, its agent, servant, previous or however called from taking steps aimed at conducting the June 24th multi-tier elections on the district block proportional representation system, is refused. That is what clearly the Chief Justice said. That an order restraining the second defendant, the Electoral Commission, its agents, servants, previous or however called from taking steps aimed at conducting the June 24th multi-tier elections on the district block proportional representation system is refused. So the commission has decided, besides it's the commission that advised the president.
I don't know, the way you read it, it's as if they're asking him not to conduct the PR system, the election on the PR system, the way you read it.
No, anyone who tend to stop that, they would refuse that because the court has given clearance.
No, you said he's restrained. They are restraining
An order restraining the
yes.
second defendant in the Electoral Commission.
Yes.
Its agents, servant, previous or however called from taking steps.
Yes, taking steps.
Aimed at conducting the June 24th multi-tier elections on the district block proportional representation system is refused. So, the question I want to ask based on this, with all that is in play right now, what do you see your party, for example, doing to ensuring that? Because at the end of the day, this is something you just have to abide by. You cannot go against it. The Supreme Court has made a decision.
Let me say, I think I made this statement the last time. The fact that the SLPP government is bent on running election on a PR system, at the 11th hour of the election, does not necessarily mean that they're going to have the upper hand.
Upper hand in what sense?
In upper hand in the elections. Elections is all about numbers. So they may be fooling themselves in trying to believe that PR system is going to help them. This election is going to be a different kind of election. Like you said, we're not going to say of course there is not a specific official statement from the party, and I want people to know that this is not an official statement from the party, but I believe that we should not accept the elections to be conducted on a PR system. The fact that the
court... What can you do when the Supreme Court has made a decision?
Well, there are other political avenues we can use to make sure that the PR system is not conducted on.
Would that be an advice you want to give to the party?
I will give that advice to the country. There are other means we can do to make sure.
What means specifically?
Diplomatic means and other ways to make sure. Listen, you see, this is a country that we should be able to protect. We do not want to hold, except they want to say the Electoral Commissioner and the government wants to hold a kind of election where people do not understand and appreciate the modus operandi of going into the elections, how the elections are going to be held. So maybe there's going to be some complications and that will tell on the votes. But you never know. It's neither here nor there. It can also tell on them and also tell on the entire nation. So whatever they're doing is not helping them and they believe it's helping them.
Perhaps the argument would be, at a time when enlightenment was not heightened, as it is right now, say in 1996 or 2002, when the PR system was introduced or was used, people went into the elections and they came out just fine.
There was enough time. There was enough time. Enough time. And like I said, you won't understand and appreciate it. But I believe that if you study the PR system in 1996, there were a lot of problems. It was not an easy, but you see, again, it was a compromise arrangement where, we're coming from this difficult war, the crisis in Sierra Leone, and people just wanted a kind of system that will take us to some form of governance, no matter what it is. Whatever that was there, they were prepared to but this is not the case anymore. I mean, coming from the hangover of the war, we just wanted to have a governance. So let's carry on, let's move ahead. But now we should not be bastardizing the Constitution, and we should make sure that we do not put democratic institutions in the country at risk. Because we have to educate the masses about, the PR system, how it's going to be conducted. And for me, 5 months is not enough. 5 months is not enough. And we all know that. And I believe the Electoral Commissioner knows it, and the President knows that.
Should this not be a point now where, say, the political parties, including the opposition or People's Congress Party, because if you talk about time, it also does not favor the ruling party. If you talk about time, because the same people you talk to, and like I've always argued, no political party has ever won a national election with just the support of its tribal kingsmen. So you have to reach out. So if time does not favor the APC, time does not also favor the SLPP and all other political parties. So how would you, the political parties, now engage the Electoral Commission to be robust, innovative, and creative in ensuring awareness, raising sensitization, and more education on the proportional representation system?
You know, Mr. Wise, the fact that it does not favor either party does not mean that we should not say the right thing to say that this particular system, you know, is not good for Sierra Leone at this point in time, and it's now been, you know, forced into the Sierra Leoneans, you know, at the 11th hour.
When you say
yeah.
When you say forced, does that not? Is that not a misnomer? Because how many
it is
you
not.
have
It
the
is
highest
not.
land,
It is not. That is my view.
Decision.
No, that is my view. Because because there are so many ways. Forcing does not mean you have to come and hold people's throats. It does not necessarily mean that. There are many ways you can force things into people. But you see, the fact that's the case does not necessarily mean it's not good, it's not wrong. I think it's not timely, time is wrong, and it is not good for Sierra Leone at this point in time. Yes, like I said, it does not necessarily mean it's going to favor the SLPP. But that does not mean we should not say things by their right name. For me, I believe that this country is bigger than any one individual or any president or any electoral commissioner or any Supreme Court or any judge. And we should make sure that we pay tribute to the very existence of this country and make sure that we hold ourselves accountable to whatever decisions we make for the country, whether it's in development, it's in the electoral system, the judiciary, education, or otherwise. We should be very serious about what we do. And we should not be playing politics with these kind of things. Whether you are in the APC or SLPP, we have to be very serious with governance. And governance does not mean you have to make sure that, for example, in this case, you conduct the elections 5 months to the election day. You change the kind of system. It is outrightly wrong, and I think the Supreme Court ought to have said that. Even if they had said all those sort of things, they should have said, well, the timing and the education of these people and whatnot, they ought to have come with those things.
Lawyer Doumbouya, I'm tempted to ask this question. Is the APC not missing its steps? Because I also followed in Parliament when your parliamentary leader, Honorable Cheno Ramadan Majuba, moved the motion to nullify the elections petitions, the instrument, citing the ECOWAS protocol on elections and democracy as a basis that you cannot change the law 6 months to elections and all of that. But then you did not get the votes required to have nullified that very, instrument.
No, I don't want to get into...
But the question, you've taken, before that, you've taken this PR matter for interpretation to the Supreme Court. The Supreme Court has said otherwise, not favoring what you were looking for. So are you not missing your steps as a party?
No, we're not. We're not missing our steps, as a party. As I said, the fact that the Supreme Court made its decision, its judgment, against the party does not necessarily mean that we've missed our steps. We're looking at the judgment. That is what I will advise. I would look at the judgment, we would study the judgment, and we'll come with a decision, at the appropriate. We'll come with a statement. From the party, we'll come out with a statement, having looked at the decision properly.
I just cited an excerpt, or I read an excerpt from the judgment, especially the submission of Dr. Abdullahi Usman Conte, saying for him, it was not the merit or demerit of the proportional representation. It has to do with the rule of law and whether or not proportional representation is comfortably situated in any democratic state. For him, it does not, fit so. But the Supreme Court is saying, and you cannot say, of course, Dr. Conte is saying that the PR system is not an alternative form of electoral system for states. So for him, they should not even countenance the PR system, especially Section 38.
No, I think he was speaking from the point of view that there are certain set guidelines in the Constitution to go into that. So my own understanding is that once Section 38, there is a guiding principle with regards to Section 38, and that is what should operate, and the only time you spill over to 38A is where you have problems with Section 38. So my own take is that if that is the case and we do not have problem with Section 38, then Section 38A, which is the proportional representation, is not in place. And I agree with him on that. It's non-existent, but the Supreme Court has said otherwise. It is the last court in the land where when they've made their decision, you go nowhere else. And I say, but so as I say, that does not mean that they will not. And I think this judgment is going to be criticized not only by Sierra Leoneans. Even if Sierra Leoneans refuse to criticize the judgment, it will be criticized.
Well, here you are criticizing it.
It will be criticized by renowned legal jurists who will be out there who are looking at judgments, especially of the Supreme Court. In the next few months, you will see, I can assure you, will see articles out there in well-established law database. Where they will look at it, they will do a postmortem on it. That is what we call peer review, and they will look at it and give their own judgment or their own take on how they view the judgment.
Well, as you say that, immediately after the judgment was handed down by the Supreme Court, our production team went out to solicit the views of ordinary Sierra Leoneans on what do they make of the interpretation by the Supreme Court. And here is what some of them have to say to our production team.
We get right as a country for use proportional representation system of election. Of course, I think it's a lawful, you understand? Because 1996, Pakaba used them, and they used them in 2002 as well, you understand? Even though reason why you for use proportional representation, doing them, Pakaba say because war just done, political party, people were not interested in politics, you understand? And people that be there disagree, they don't get a definite constituency, so now maybe they be use them. So in this case, I think say, because according to the constitution, I guess, say, before election, when we don't do a boundary delimitation, that is when I cut the country into constituency for election purpose. But now they don't do them, which means say time don't catch election day in the next 5 months. You get now. I think say yes, proportional representation. I think say a nice system because other countries like Australia they use them. Now, what will be they use that first past the post, that majority type of election wherein as you don't win, everything done. So assuming in the election wherein you get 50% and the other one get 40%, you get. So now you win everything. That 40% don't get any representation, right? But in this system now wherein you can still get, according to the percentage where they get for the election, at the same percentage you get in a parliament. You understand? So if election can now, let's say the district party A get 35% of the total election cast or vote cast, they still get 35% of the parliamentarians in a parliament, which means that this every facet of the community is being represented. You understand? It's been hard. They minimize cost. They also minimize time because government get to spend a lot for cut the boundary.
Well, we got some passing judgment, but as a citizen, we're not pleased with that because the reason based on we the people and they get the chance again for choose the leaders, them, especially the parliamentarians, them, where we they against. You understand? In as much it got some passing decision, we they look at a decision on their own. But be as it may, we therefore go with and bear them. But good, especially for me, they talk for myself, we may not appreciate that.
The PR system is common. At least the constitution of the organization will not have problem with that because the PRC and hold the people's life. And I believe so before we recommend somebody, for instance, for this area, this Gangwai area now, we use somebody as an meeting, as a parliamentarian. So I believe so now the one where the people that meet, we don't feel say at the end of the day, they really make good progressive movement in the area, they really make tracks record. I believe so it's the best.
Well, the PRC system and we are very glad because when you look to the youth and the streets, the majority youth lawless. You know what I mean? So man they go pay youth, get youth for demonstrate. PRC system is glad because it is count savior of the country because alone big pass through. That is the message where they go to make a contest for the street ambassador, but tell the youth stay. Let everybody not use now for demonstrate. So this PRC system we come, Mr. glad you're happy because you don't put load for majority people. So the police themselves, you don't put load for them. Everybody getting party, you go campaign at the corner for your party. You know what I mean? I can go the message. But this, if they say rallying at the street, it will come problem. But if the system way don't come, we all are happy. And they go on the ghettos, go on the corners and ask the youth man everything and I mean. They say we not get no problem because the youth man themselves cool. They say what they want let the country go before.
All right, we still have not seen the country's Solicitor General, lawyer Robert Kowa, Francis Gabidon, lawyer, and Rashid Dumbuya. We are still hopeful that they would be part of the conversation. They would join us here tonight. Interestingly, lawyer Dumbuya, at this point, what should be the focus of your party? I mean, the APC, because legally, all the things you've pushed for, you've not been successful. Maybe is it that you do not know the law? Is it that maybe there are things you're not getting right? Because, you know, so, a friend of mine who is a very senior legal practitioner who has molded generations, for example, in the law profession, told me when your team, your legal team was, I mean, making submission, for him, it was more of a trial. So what is happening with your party? You know, I mean, many said you have fine legal brains. What is going on?
When you're making that statement, I recall somebody was saying, you know, that the APC, some of the grassroots people, that the APC should not go to this court because this court does not like the APC. As a way of strategy, I cannot say it outrightly here, but as I say, we're looking at the judgment, and the party will come out with a statement at the appropriate time, and it's going to be sooner than later. But we're looking at the judgment, and we, as I say, we're going to use political means and also diplomatic means to ensure that the country is put on the right track. Because if we miss the mark, then it's going to be a problem for this country. I can see that people are desperate. Desperation can bring serious problems in any institution, whether it's a country governance or in many other spheres. And that desperation seems to be lingering in you
mean APC supporters?
No, I'm talking about the government, you know, the desperation of the government in trying to push certain agendas, you know, is really not helping the country.
Well, how do you determine that desperation? In the sense that, especially when you, for example, you've submitted here that it does not guarantee winning for the SLPP.
Yeah, I agree with you. But you see, again, Mr. Wise, the fact that it does not guarantee winning for the APC or anybody else does not necessarily mean that we should continue doing things that are wrong. It's bad for governance. It's bad for democratic institutions, and it's really going to bring a situation where we do not want to go back into a system where this country is going to go into something that we would not like. We want this country. We've come a long way. We want this country to be at peace. We want this country to respect each and every one of us, to respect democratic institutions and democratic principles, so that the country will develop that culture. For me, it is really sad that we have got to this point. And I say this not out of malice, but out of concern for the country. I just hope that the Electoral Commissioner decides that the elections will not be conducted.
What is out of point here? You have, a political party or members of a political party who felt that they've not been treated fairly. Provisions in the Constitution have been breached or violated by the ruling party. Members of those party took the matter for interpretation. The courts, which is, by the way, the practice is like, in any democratic or good governance space, that is what obtains. And so what is really sad, because if they've gone to the Supreme Court, then of course they depended on the judgment of the Supreme Court too. And the Supreme Court has come out clearly.
Well, the Supreme Court, as I said, they've made their decision. And like I said to you, I have tremendous respect for almost all the members of the bench, and I'm surprised that they've come up with that. I have to say this, I'm surprised that they have to come up with that kind of decision when you look at, because the only thing...
If the decision had been the other way, would you have been surprised?
No, you see, let me say this. There are certain things in the Constitution, they are black. If they are black, they are black. If they are white, they are white. You don't try to change them. But when you look at 38, and you look at 38A,
I'm actually trying
there is no room for ambiguity.
I'm actually trying to get a member of parliament, lawyer Indolo Gevao, to comment on this, the judgment of the Supreme Court on Friday. So when I'm able to establish contact with him, which I'm pretty sure that will be soonest, then I would also get his own side, since we've not been able to get the Solicitor General here with us.
But of course, Mr. Gevao is going to endorse the PR system.
You are against, because you're a member of the APC.
No, you see, let me say, Mr. Wise, for me, I am a different kind of person.
Right.
I want things to go proper for this country. And when I stand, to ensure that the right thing is done, sometimes, yes, people would say, okay, you belong to the APC, therefore, because it favors the APC, that is why you are now saying this. But forget about what I am saying now. Take Section 38 and 38A of the Constitution. Send that to any jurist out there in the world. Or take the entire Constitution of Sierra Leone and say, is there any way the country can, go into proportional representation based on this principle? Yeah. And you give the person the scenario. The last time the census was, the census were held, and the census was held, and the last time the constituencies were delimited and demarcated. And you say this is the timeline. You give them all the numbers and the figures and the dates, and say, can we go on a proportional representation system, the district block system? I believe that they will say no. So sometimes we don't limit it to me. Give it to your friends out there. Tell them, say you want them to help you on this issue, so that you can also be assured that what I am saying is wrong or right. As I say, I'm not saying that I cannot claim to be clever, but there are certain things which I appreciate, and when the English is clear, plain and simple, in the Constitution, it's not ambiguous, there's no ambiguity, I fail to see why I can be forced to interpret it otherwise.
Lance Adumbia, stay with me. I think I've been able to establish link with lawyer Indolo Gevao, a member of parliament representing the Sierra Leone People's Party. Honorable Indolo Gevao, good evening and welcome to AYV on Sunday.
Good evening, Samuel. Good evening, listeners.
And thank you very much for accepting to speak to us in this short notice. Honorable Gevao, First off, what do you make of the landmark ruling by the Supreme Court on the proportional representation last Friday?
Firstly, Samuel, I really want to commend the judiciary for coming out with a judgment within the shortest possible time. And in my opinion, it's one of the best judgments that the Supreme Court had ever handed down on a constitutional issue. You know, I am one of those people who believe in my case. I normally say, there is this legal adage that says a lawyer is as good as his case. I mean, the case that was presented before the Supreme Court by the All People's Congress lawyers was really, really very weak. Right from the start of their papers, their application had no limb to stand on. When I looked at the prayers that they were asking for, and I looked at the affidavit in support of their prayer, I told somebody in a magistrate court before, a very senior colleague, Roland Wright, that, I mean, they were just embarking on a child's play. So, the Supreme Court took their time, irrespective of the fact that their papers were weak. They really took their time to elicit the legal element in the what ought to have been submitted to them, and actually came out with a very sound judgment. I was just listening to my colleague, very senior colleague, Lansana Dumbuya. I mean, the fact here remains that the PR system, like I had always submitted on your medium, is constitutionally provided for. All what we have been canvassing on your medium is just what the Supreme Court went and recapitulated. You know, so for me, Samuel, it's one of the best judgments the Supreme Court really did. I mean, justice to the application that was before them. And the part of it really that I admired was the fact that they told the public that the president did not act up to his powers. I mean, that was it. He acted within the ambit of the Constitution. He took necessary procedures, the right procedures, in reaching to him directing the Electoral Commission to actually proclaim that we'll be going by proportional representation. I mean, I always tell people, like a lawyer, I normally tell my colleague Roland Islander that if you take everything away from him, what he knows is law. If you take everything away from President Bio, he knows politics and he respects the Constitution. Never had I seen that man go against a constitutional provision. So he did what was right. The Supreme Court just came and reaffirmed that the processes that he followed was correct and that he did not act outside his constitutional mandate. For me, it's a brilliant judgment, and it's a judgment that has really, advanced our jurisprudence as far as constitutional issues are concerned. On the other one hand, I want to commend the All People's Congress, because this is what we expect them to do. Before now they used to fight with their fists in Parliament. This is what you do. When you think you have an issue that has to do with the interpretation of the Constitution, come to the Supreme Court. They will always hear you. They came to the Supreme Court, albeit with a very weak case. The Supreme Court heard them and delivered a brilliant judgment, which will stand the test of time. So for me, it's one of the best things that have happened to Sierra Leone.
What does this hold for the June 24th elections? Because Lawyer Dumbuya here clearly submitted that going with the PR system does not give advantage to either APC or SLPP, but there is no time for the people of Sierra Leone to understand the form of the system, especially when they will be voting.
He got it right. It's an electoral system that is meant to put all parties at par. That is not really meant to give one party advantage as against the other. So on that issue, himself and I were on the same wavelength. And on the issue of there not being time, I always tell people that PR system had been used before. This is not the first time that we are using PR system. It was used in 1996. It was used in 2002. Lawyer Dumbuya, I am sure, voted members of parliament then on a PR system. I don't need education. The people in my constituency, honestly, do not need education. For those who are first-time voters, when was it? On Saturday morning, I was there on the radio educating them as to what the PR system is all about. Sierra Leoneans are among the most brilliant people on the globe. Our intelligence quotient is really high. You check the index international, you check the global index. Within 1 week, by the time let's hit the ground running with regards public education. Trust you me, everybody is going to grasp it. Like yourself, Samuel, I always tell people that waste not your time, go and read law. You've been able to understand the PR system and you can deliver a paper on it. You can lecture Sierra Leoneans on it. It's a very simple principle of process. It's not rocket science. You know, so for me, there is enough time. 1 week, 2 weeks, everybody will be able to understand how they are going to vote. It's just about you telling people how they are going to vote, how their vote is going to turn out with regards distribution of seats and representation. For me, that is it. It's not mathematics. It's not jurisprudence. For me, it's simple explanation that anybody can grasp in the middle of the night if a lecture is given to him or her.
Gevao, just quickly, Lawyer Dumbuya submitted that, of course, he is criticizing the Supreme Court ruling. And you have described this as one of the best things that has happened within the judicial sector of this country. How so?
Samuel, I'm one person that says the judiciary has one of the most difficult jobs cut out for them in Sierra Leone. I mean, right from the magistrate court to the Supreme Court, when anybody loses a case, they will say, oh, this magistrate, this judge went against me because of ABCZ. I mean, somebody that loses a case never goes supporting the presiding officer who actually presided over that case. We hear it over and over. But they have a job to do. That is their job. I mean, if Lawyer Dumbuya, if the judgment had gone in favor of Lawyer Dumbuya, we was going to be clapping for them. I would have been saying, no, I'm disappointed with the judgment. It is expected. I mean, only that he is one person that I have the greatest of respect for. He is one person that I was really expecting to give thumbs up to the judiciary for such a landmark and brilliant judgment. When the judgment was handed down 2 or 3 years down the road to say the president has the power to sack the vice president, I did not agree with that position. Lawyer Dumbuya and other lawyers were very happy over that position. They clapped. But I did not go criticizing the judiciary. Somebody has to do that job and to actually come out with a judgment. So for me, these are people that we ought to be commending when they do a good job. I mean, presiding over matters in the Supreme Court is not an easy thing. Coming out with, a 2-hour, 3-hour judgment and being delivered, it's not an easy job to be done. These people would have sat down looking at interpretation canons, looking at laws pertaining to the prayers that we are being asked for to have arrived at that decision. So I was really expecting him, being a very senior counsel who actually knows the nitty-gritty of law. I was expecting him to actually commend the judiciary, and that's the problem with us. When it is not right, we criticize. When it is green for us, we comment. On this occasion, honestly speaking, even if you ask one of the critics of the judiciary, Augustine Mara, he will tell you, one, he was happy that the judiciary came out with a judgment within the shortest possible time. Secondly, that it was a brilliant judgment. I read his tweet. He was saying somebody ought to have dissented. His only disappointment was that there was no dissenting view. But it's not a hard fast rule that there must be a dissenting view. So no matter what you say, Samuel, even if it's an LLB1 student sitting on that case, that matter would have been kicked out of the window from the word go. It was a weak case, very weak, that if I were to advise them, I would not have advised them to file such an action in the Supreme Court. And if I were to be a Supreme Court judge, I would have asked for, if I were to be the Attorney General, I would have asked for very huge cost. Because sometimes when you just bring before the Supreme Court frivolous applications, definitely you waste their time, and everybody foresee the outcome of the matter. It comes out that way. It was not an unnecessary waste of time. The Constitution makes provision for PR system. Did it? Yes, it did. The president followed the requisite procedure in proclaiming the PR system. All what they were saying, constituencies have not been dissolved. Fine, constituencies can dissolve the moment that Parliament dissolved. Those constituencies that are in existence will no longer be qualified to return a member of Parliament to Parliament as they are. It was a simple argument that we canvassed on AYB. Over and over, myself and even Abdul Kabo, who was a plaintiff, he did not believe in his case because he got to understand where the president came from, but had to file just, hard to find because as usual as their style is, they want to always be seen, to say they've done something, even when they know it will go against them. Let me tell you something, Samuel. Just a few days ago, we had the election petition rules before Parliament. When we looked at Parliament, the APC members were not up to 15. The SLPP members were up to, let's say, 42. Now, they knew even if they had said we ought to have gone by voting, they knew they were going to lose. But yet, because they could not have got two-thirds, yet they had to vote a motion for us to vote. We voted and we lost, and they lost. There are certain times where you really know that the thing is glaring, as white as broad daylight. Don't fight.
Lawyer Gevao. Lawyer Gevao, do you see the Supreme Court's ruling as one that justifies, that's not the word, as one that vindicates, as we're running out of Topopia, as one that vindicates the ruling SLPP from accusations of it being bastardized in the country's constitution?
Samuel, I've always challenged my colleagues on the AYV medium to tell me one instance where this SLPP government has bastardized the constitution, and none of them had ever been able to show me one instance. I always tell the public that while the SLPP fight with their head, the APC fight with their feet. Anytime you see SLPP coming out with a constitutional issue, trust you me, Samuel, if it's something that they have started.
We're running low on top up here. We'll definitely join you soonest again, please. That was Lawyer Indolo Gevao, honorable, representing the Sierra Leone People's Party in Parliament. You've had over an hour with me in the studio. So please, I have Lawyer Lansana Dumbuya, who is aspiring for the Secretary General post of the opposition All People's Congress Party, criticizing the judgment from the Supreme Court handed down last Friday. We have so many messages already on Facebook, and we'll have to run through some of them. But just before I run through some of the comments, Lawyer Dumbuya, I know you would want to respond to some of the submissions.
I told you beforehand that Gevao is going to support the judgment from the point of I don't believe Gevao is supporting it from the point of the legal aspect or legal eye, He's supporting it from a political point. You see, so he made a very nice and beautiful cosmetic political statement and not a legal one. To say that the Supreme Court did well in coming out with the decision, he said he asked a colleague, a very close colleague of mine, Mr. Mara, was happy that the decision came out, at the time.
Was speedy.
Within a very short very short period of time. I also acclaim the Supreme Court for that, and I think I join Mr. Mara in that and commend them for coming out with the decision swiftly like they did. But that, I don't believe that he asked Mara as to whether Mr. Mara agrees with the reasoning behind the judgment. And the fact that they came out very swiftly does not mean I agree with what they have said. So I also want to tell Mr. Gevao, if he wants to come and have it out with me here in the AYV to show various aspects as to how the Constitution, has been bastardized, or, the government has gone against the Constitution in so many areas, in the electoral process and in other areas, from the speakership of Parliament on to the last bit. There are so many instances. I can give him all the areas if he wants to. He can ask for a date and we can come and have the debate here. But as I said, it is Mr. Gevao mentioned the aspect that in fact the Constitution, it is constitutional. You see. There's no doubt about it. We are not saying that according to 38A, which is the Constitutional Amendment 2001, it is not in the Constitution. We're not saying that PR system is not in the Constitution. That is not the argument. The argument is it constitutional at this point in time for the PR system to be implemented? That is the basis. That is the argument. It is not whether it is in the Constitution or not. We know it is in the Constitution by the 2001 Amendment Act. That is Section 38A. It's there. But is it right for it to be implemented? And I say no, it is not. Because the life of the constituency ends next year, December. I don't understand how simple I can put it to people or the populace to know that the PR system has no legs to stand on constitutionally, because the life of the constituencies are still, even if Parliament is to be, Parliament, the life of Parliament ends in March. Still, that does not mean because the life of Parliament ends means the life of the constituency should also end. That is also a wrong reasoning. You know, the life of Parliament ends in March. The life of the constituency ends next year, December, because next year, December is going to be 7 years from when the constituencies were delimited. So I don't know how simple. That is why I don't appreciate really what Mr. Guevara. But I can understand Mr. Guevara. He's a very good friend of mine. I can appreciate. But also, what I want to tell Mr. Guevara, I want to say now you have said that in fact the PR system is well and good. Well, good to you, but it's also good for you to make that nice political statement, and I appreciate. I only pray that your name will be inserted in the list for Parliament this time when it's not constituency.
All right, you both have referenced the tweet made by Augustine Soisembe Mara, lawyer, and there's what he tweeted. He said, the Supreme Court has today delivered a judgment confirming the PR electoral system. As a legal scholar, I was looking forward to a concurring or dissenting opinions. Does it look good at all? Does it look good that all 5 judges would agree on every letter, syllable, and reasoning of such historic judgment? That is what Augustine Mara tweeted. But let me run through some messages on Facebook. We have many of them. Our viewers and our followers, including our listeners, they've been very, very I'm interested in the conversation. Ronald Breastford Ignatius Georgetown is saying, just the removal of a sitting vice president was seen as a right by the same judges, but was ruled as unconstitutional by ECOWAS. We now see service return by this government due to executive powers bestowed upon both successive governments. I have nothing against the PR system, but it could have been brought in at the first opening of the first parliament. How can the electorate be schooled on the PR system with only 6 months to an election? Abbas Habib Kuka is saying, wow, well, go to the ECOWAS court. Oh, I forgot. ECOWAS court doesn't have any say in Sierra Leone's business, according to former Attorney General Joseph Fitzgerald Kamara. Mohammed Kamara is saying, I am happy that lawyer Francis Gabidon, well, we're happy, but he did not show up. He's one of the trusted lawyers in this country who will definitely give us. Unfortunately, lawyer Gabidon is not here. Bakari Sao is saying, so Dumbuya is saying the justices are wrong, but yet still he's saying he's going to look at the judgment of the justices, which implies he has not looked at the judgments yet. All right, Lamin Denke is saying we would never get fair judgments in our court unless the power of appointment for judges is removed from the president. What else would these, or what are they trying to say? The biggest court of the land had decided. Who are you to deny it? Fuad MB Mansari is saying, Kamara Charles is saying here, lawyer Dumbuya, the lawsuit was not between APC versus SLPP, but APC versus the state. Why are you calling the name of the chairman of SLPP in this? Interesting. David Sisi, interesting. Bakaisa is saying, yes, there are existing constituencies, but there was a midterm census, so-called lawyer Dumbuya. The end result of a government that is not too clear. This statement by lawyer Dumbuya about refusing to acquiesce to the PR system is dangerous and politically toxic. Michael Koka is saying, I'm going to take at most 5 more messages because of time. Conte Mohammed is saying, our country's democracy is currently being threatened. Where are our moral guarantors? A question being asked. John Abu is saying, this lawyer is craving for... and lawlessness, but he should know that he is now on record should anything come from the APC in that direction. That is not so clear. Baba Ahmed Mansari is saying, good evening, Samuel. As long as the ruling doesn't favor the APC, they would have problem with the ruling. Selfish politicians. Ibrahim J. Oscar is saying, the way I see the APC, nothing is good for the country. The midterm census and the PR system. So what is good for the country now? Wahab Muhammad is saying, the PR system or the constituency system, we are all Sierra Leoneans and we need to put our country first. Vision 2023, okay, that's not what we're here to discuss. I think lawyer Lansana Dumbuya is just beating a dead horse. Why didn't he go to argue in the Supreme Court? This is just another waste of time, Mike Dean is saying. 2 more messages because of time. How frequently are we going to keep having proportional representation as provided by our Constitution? Lamin P. Albert is asking. Eddie Grant is saying, Lawyer Dumbuya, do not allow your emotions to carry you away. Finally, from Alhaji Amarakibe saying, the law is the law. What other means do you want to take when the highest court of the land has made its ruling? So we have many messages, but unfortunately time would not allow me to go through all of your messages. Let me allow you quickly to respond to some of the messages of the lawyer Dumbuya.
Well, I can see that when it comes to legal aspects, most Sierra Leoneans do not appreciate the kind of provisions in the Constitution and will not be able to interpret it. So once the Supreme Court has given its decision, for them it's the gospel truth, and that's how it is.
Exactly.
I mean, that's how it is.
That's how it
no,
is
that's how it's really.
law.
No, that's how it is. But that does not mean I should not disagree with it, you know. And I say this: people want to misunderstand me. The fact that I disagree with the judgment does not mean that, you know, I have problems with the judges, I have problems with the law. It is my right to disagree with a judgment given by the court. That is democracy. That is democracy. So if people are talking about democracy, they must also appreciate and understand that it is within my right to do so. And for the gentleman who decides to issue out a threat that my name is out there, my name has always been out there, and my name has always been in all the other lists that you can think of. And I am not afraid. I'm a Sierra Leonean. I'm made of standard stuff, and I follow the law. And I believe that the proportional representation is not ripe for Sierra Leone, and that is what I say candidly in the interest of the country. And
you have been asked why you are not part of the legal team representing the plaintiffs.
With regards to me not being part of the legal team that day, I think I went to the doctor that day. I was ill. Even now, I am just recuperating. I was not feeling too good. But I've always been there with all the legal team and all the legal representation. They know that. And so if I was not there that day for the judgment, well, I was not there, but the judgment was read anyway. Nobody waited for me. So, and my presence there was not going to give the judgment the judges, right? The judges to argue otherwise, that in fact the PR system should not be implemented by the Electoral Commissioner. Once they have made up their minds and they've decided on what is right for the bench as a Supreme Court, that's what they were going to do, irrespective of whoever is present or not.
We've been able to establish link again with lawyer Indolo Gevao. Lawyer Gevao, we apologize for earlier, but just quickly now, what does this ruling, where does this ruling put the June 24th multi-tier elections?
All what the ruling has said is the fact that a constitutional provision has been invoked, and it has been invoked properly. And that the multi-tier June 24 election has to be run based on the proportional PR district block system. So, for me, the onus actually now lay with the Electoral Commission for them to do the public education. Like I said, all old-time voters knows how to vote. There are people in parliament like Honorable Veronica Kadisi, who went to parliament through the PR system, and up till now she is in parliament, albeit during this inning on the first past the post system, which is to tell you, we use the PR system just yesterday, that people who benefited it and entered into parliament are still in existence, they are still living. So it's just for us to go and vote. Like the Supreme Court said, what is most important is the right of the citizens to vote, which has not been taken away.
Would you at this point, as a member of the SLPP, would you look at how you, the different political parties, would also scale up education for the electorate to understand the system better? Because all what the different political parties, including the SLPP, has agreed on is that there is not enough time. So you, the political parties, also have your education role to play. I mean, how much of an awareness would you want to raise? How much of a sensitization would you want to give to electorates to understand the system better? So at the end of the day, we have elections that the people really speak and they have their decisions read out.
Samuel, that is the way to go. You know, we are the people's representative. Sometimes it baffles me when something has to do with the people, parliament is not being used. Like I told you, I'm just coming from Kailahu. On Saturday, I did a voice recording which is being played in Kailahu every morning, every evening for people to start understanding, those who do not understand what the PR system is all about. The way to go is to use members of parliament and councillors. When we send the message down there, it filters down there within the shortest possible time. The people are expecting us to go talk to them. So if NEC can use us, I think they can get the public education done within the shortest possible time, because nobody understands the PR system as much as we, the members of parliament, we who are primary beneficiaries of the system, do. You know, so let them use us. We are ready to work. It's part of our job. We are the people's representatives. Our mandate still runs. Let them use us for us to go and tell the people what PR system is all about for those who don't understand.
Lawyer Dumbuya is saying you are claiming the Supreme Court for the judgment simply because you're a member of the SLPP and it favors your party.
Lawyer Dumbuya knows that I'm one of those Sierra Leoneans that is highly critical. I am a very decent patriot. When it is black, I will call it black. When it is green, I will call it green. He knows me for that, just as I know him to be a very decent practitioner. I once told him during the APC days, he had just come from the Hague. A certain magistrate asked SLPP supporters who were in court to witness the case to step outside. And he said, no, trial has to be in public. He's a decent man. He knows what I am saying is the truth. They filed a very weak case. Their case had no limb to stand on. The Supreme Court did just the right thing within the shortest possible time, and they should accept it. I mean, we should not always cry down an institution when it doesn't go in our favor. If that judgment, if I knew the case, I mean, right from the argument, when Kano Esquire was arguing for on behalf of the state, everybody in the court, even laymen, knew the APC was going to lose the case. My mom was there. Lady Nanette Thomas, she was there. She had to leave the court. She met me at the stairs. She was disappointed. So even people who were not lawyers were really disappointed when Abdullah Conte finished his argument and the state council, the state lawyers started submitting. They had a very weak case. A lawyer is as good as his case. If he had a bad case, he had a bad case. APC had a bad case. And there was no way the Supreme Court was going to rule in their favor just because they are in the opposition or they are APC. The duty of the judiciary is to hold the scale of justice untilted and let the hammer fall in the right place.
Does this ruling put an end to the argument of PR, no PR, and whether or not the conditions that should be met or not? I mean, going forward.
It certainly does. This ruling certainly does. I mean, the Supreme Court is the highest court of the land. This court has vindicated the actions of the president. This court has said the action of the president in directing that NEC conduct the election by PR system is constitutional. So that ends the argument. What every Sierra Leonean should be looking forward to now is getting the necessary education for you that do not have it, and raise yourself up to go and vote during 2023, during the June 2024 election, using the district block system. It is part of our constitution. It did not come from heaven like manna from heaven. APC came, they met it there. If they knew it was not a good system, they were going to repeal it. They did not repeal it. They left it in our constitution. If SLPP thinks it is a good law, they will leave it there. Constitutional provisions are meant to guide us. That is the ground norm. So once the Supreme Court has interpreted it to mean to say the actions of the president is constitutional, that ends that argument, my brother.
Just quickly, as I asked you for your parting shot, for the APC, this judgment appears to be a nightmare. For the SLPP and the Electoral Commission, for example, it's a fascinating outcome. But as we head towards the June 24th multi-tier elections, what should we focus on, and what should be your message of peace?
My message of peace, firstly, is for me to talk to my brothers to stop playing the victim. Like I said, filing that paper, those papers in the first place was trying to play the game of the victim. They knew they had no case. Let us respect constitutional provisions. Let us respect our institutions like the judiciary. Let us commend them when they do something right. Let us cry them down when we know they've come out with something wrong. And let us know we are all but one country, one people. We've got nowhere to go, but Sierra Leone. Let us hold each other together. Let us stand together so that there will be no tornado. But that even if there is a tornado by people who are not patriots, we will be standing together, and it will leave us unbattered. It's politics, Samuel. You've been to America, you've been to England. In those countries, elections come and go without people even realizing that there was elections. They just send your ballot paper in your post. You take it at any time of the day. You just go and cast your vote. We've witnessed elections in Canada, in America, in London, in Sierra Leone, because we think elections without politics we cannot survive. That is why we are having this entire hue and cry. People should be able to survive away from politics and look at politicians as public servants who are there to deliver for them.
All right. Thank you.
I always tell people now that petrol is 20,000 leones. No SLPP is going to buy a liter of petrol for 5,000 leones, and APC person buys it for 20,000 leones. If Sierra Leone gets better, it gets better for all of us. Now they are constructing an overhead bridge at Wilberforce. It is not going to be discriminated. We are not going to discriminate as to who uses it. The Maban Bridge, they don't discriminate as to who uses it. The 24-hour light that we are enjoying in Freetown, they are not discriminating as to who uses it. So when Sierra Leone moves ahead, indeed, we move.
Thank you.
Thank you. This is the 21st century. Let us be part of the revolution of development, which is the agenda of President Bill.
Thank you. Thank you very much, Honorable Indolo, for your time and the fact that you accepted to speak to us in such a short notice. But just quickly, Lawyer Dumbuya, as we try to wrap up the conversation, what would you submit as your parting shot?
First of all, let me just say this to Mr. Guevara on the issue of the PR system. I am putting out there a challenge to Mr. Guevara. Friendly challenge, of course. He knows me. He's a very good friend. He's a bosom of mine. But just for the purpose of edification, to educate the masses. Let him come along with the Constitution, I'll come along with mine, and specifically we come and debate on Section 38 and 38A. That does not mean it is going to change the ruling of the Supreme Court, but let the populace, let the general public see the fine print of 38 and 38A, and where exactly Mr. Guevara is coming from when he's saying this thing is constitutional. For me, I'm saying it's unconstitutional, and with due respect to the Supreme Court, they've made their decision. It's final. I have tremendous respect for all of them in the bench, but that does not mean that they are also infallible. They are human beings. They are not infallible. So even the most renowned judges in London, their judgments have been criticized by legal academics who've looked at it. And as time goes on, some of them changed their minds with regards to what they initially decided. With regards to Mr. Gevor is saying that nobody is enjoying less of the 24 hours light. Mr. Gevor knows that we are not enjoying 24 hours light, and that is a political statement which is wrong. And you see, these are some of the things that sometimes happen. And when I say Mr. Gevor is saying it because he's SLPP, he will also say, I'm saying there is no light because I'm APC. But the thing, there are practical things. The country has totally been put into complete blackout. You have the light going on, and when the light goes off, it comes off again. Sometimes it goes forever. We never used to have that in the country. Right. In any case, as I said earlier on, the fact that I said we're going to look at the fine prints of the judgment does not mean I have not read the judgment. It's a voluminous one. When you are reading a document, you read it at first instance, right, and then for you to get the gist of it, you go over it again. That's what I was referring to. So the person who was saying that I have not read the judgment took my statement out of context. If he had listened to me, I'd said I've had a cursory look at it in the first instance. So sometimes when we're listening to people, we have to really appreciate and listen carefully before you. But anyway, I want to thank all the critics.
How influential can your advice be to the APC party in exploring other avenues?
Well, I cannot say to you now what is going to happen. But I'm going to make that representation, and we will sit and talk, and the party will come up with a statement for the general populace. But as I said, it's not, for Mr. Guevara, I think he was more or less talking about politics. For me, some of these things are not about politics.
Let me allow you to speak to Sierra Leoneans in terms of peace, the need for us to keep the peace.
Yes, it's not all about politics, really. And a lot of other people make certain statements. I want to thank them. Whether you criticize me or not, or you applaud me, it's well and good. It's within your right, and I appreciate it. But let us all ponder over what we're doing, each and every steps we take, every words we say out, and the actions we take, whether it's at governmental level, whether it's the institution, schools, whether it's also here at this studio, AYV, or within the family, or within friends. We have to make sure that we take decisions that will benefit the country. Because if we fail to take decisions that will benefit this country, then we have all been remiss in our duty to make sure that Sierra Leone gets to a point where we all say we are family, and we can live in peace, and irrespective of the political differences, the ideology or whatnot, but we all should ensure that we do what is right for Sierra Leone.
Thank you. Thank you very much, Lawyer Lansana Doumbouya, an aspiring candidate for the Secretary General post of the Opposition All People's Congress Party. We do apologize for the absence of the country's Solicitor General, Lawyer Robert Kowa, Francis Gabidon, and Lawyer Rashid Doumbouya. We do apologize for their conspicuous absence in the show tonight. Many thanks to those of you who followed, who dropped your comments, shared your thoughts with us on the AYV News Facebook page, those of you who watched us on AYV Channel 33, DSTV Channel 399, and those of you who listened to us on the radio FM 101.7. This is where we end tonight's show. Be sure to catch a fresh edition of the show, same time, same station next week here. And until then, the show has been AYV on Sunday. My name is Samuel Wise Bangura, and up next is our AYV Primetime News. Till we meet again, take care of yourself and have a lovely night.